They called me my father's greatest weakness. 4 days later, the board was preparing to sell the company he had spent 15 years building. They accused him of hiding millions inside a secret trust for his adopted daughter. They forged a story using his real signature. They offered me the career of a lifetime if I quietly disappeared before the hearing. Even my own brother looked like he had chosen their side. But what none of them understood was that the little girl my father once found standing alone in the rain had grown into the only person who knew why one missing document could destroy an $860 million empire. My name is Maren, and this is how the people who called me his greatest weakness became the reason they lost everything. Chapter 1. The key he placed in my hand. The first time Barton Kingsley called me my father's greatest weakness, he thought I was too far away to hear him. We were in a federal courtroom in Baltimore in October of 2025. My father sat at the defense table in a white shirt and the same faded canvas jacket he had worn for years, even after Vail Atlantic Logistics became a company worth nearly $860 million. Silas Vail had never learned how to dress like a man people feared. He still looked like someone who might step outside during recess to check an engine. Across the aisle, Barton leaned toward his attorney, Elliot Wainford. "She is the last weakness Silas has left," he murmured. Judge Margaret Ellison was reviewing a request that could suspend my father's voting rights and strip 19% of the company's shares from the protection of the Vail Founders Stewardship Trust. If she granted it, Barton could push through a merger that would cost my family control of the company and put more than 1,000 employees at risk. I had not yet told anyone what I carried into that courtroom. Barton was wrong about what weakness looked like. But he was right about one thing. The fight had begun with me. 15 years earlier, I was 13 years old and standing beneath a cracked awning near the old Greyhound terminal in Baltimore. It was April, but the rain had the hard, cold edge of winter. Water had soaked through my shoes. I held a plastic grocery bag against my chest because it contained the only school records I still had. Everything else fit inside a torn backpack. One change of clothes, a notebook, a toothbrush, and $3 folded into the back cover of a paperback. I had left a temporary home that afternoon because staying had started to feel more dangerous than sleeping outside. By then, I had already learned that adults often made promises while they were looking directly at you. They said they would call. They said they would come back. They said the next place would be different. Then responsibility became inconvenient, and they disappeared. I saw Silas before he saw me. He came down the sidewalk in work boots and dark coveralls, carrying a metal lunchbox. Grease marked the cuffs of his sleeves. He looked tired enough to pass me without noticing. Instead, he stopped several feet away. "Are you waiting for someone?" he asked. I did not answer. He looked at the rain, then at the thin jacket I had pulled tight around myself. "I am not going to come any closer," he said. "I am going to call someone who can help." He took out his phone and contacted the police. Then he asked to be connected with Child Protective Services. He did not try to touch me. He did not ask me to get into a car. He stayed where I could see both of his hands. A few minutes later, he crossed to a nearby convenience store and returned with a paper cup of warm milk and a cheap blue coat. He placed them on the dry part of the sidewalk between us. "You do not have to take them," he said. "They can stay there." I waited until he stepped back before reaching for the coat. He sat on the edge of the curb while we waited for the social worker. Rain collected on his shoulders. He could have stood beneath the awning beside me, but he did not want me to feel trapped. When the police car finally appeared at the end of the block, I looked at him. "Will you come back?" I asked. He studied my face for a moment. "I will stay until they get here," he said. "Tomorrow morning I will call and ask where they took you." He did not promise anything larger than he could control. That was probably why I believed him. He stayed until the social worker drove me away. The next morning, he called. For several weeks, that was all he did. He called the office. He asked if I was safe. He spoke with my caseworker. He did not ask for information he was not allowed to have. He simply kept showing up in the small ways the system permitted. Eventually, he asked what it would take to become a foster parent. Silas was 37 then. He was a widower, raising his 15-year-old son, Evan, in a small rented house in Dundalk. He worked as a diesel technician near the port and had little savings. Every practical fact argued against adding another child to his life. A social worker asked him why he wanted to take on the responsibility. Silas did not give her a noble speech. "A child asked if I would come back," he said. "I do not want to become another adult who teaches her that promises only matter when they are convenient." He completed the background checks, classes, interviews, financial reviews, and home study. I remained in temporary foster care while the process moved forward. Near the end of 2010, I was placed with the Vales under supervision. Evan did not welcome me with open arms. He was not cruel. He was careful. His mother had died several years earlier, and he had built a life in which it was just him and his father. I was a stranger, carrying a plastic bag of school records into the room that had once been used for storage. On my first night, I found a clean blanket folded outside my door. Evan stood at the end of the hallway with his hands in his pockets. "Dad says you do not have to leave," he said. Then he walked away before I could answer. It was not warmth, exactly, but it was the first thing that felt like permission. The adoption became final in September of 2011. After the hearing, Silas drove us home and asked me to wait on the porch. He unlocked the door, stepped inside, then returned with a small brass key. He placed it in my palm. "In this house, you do not have to ask permission to belong," he said. "No one gets left outside in the rain." He never mentioned gratitude. He never told me what I owed him. I put the key on a thin cord and wore it beneath my shirt for years. In March of 2012, Silas rented a leaking garage in Sparrows Point and started Vail Harbor Freight with 3 used tractor units. Evan spent weekends helping him repair engines and check routes. I sat at a folding table, entering invoices into an old computer and sorting paperwork into cardboard boxes. Drivers came through the garage with contracts they barely understood. One afternoon, I watched a man sign a document after reading only the first page. Silas took it from him and handed it back. "Read the rest," he said. The driver laughed and said he trusted the company. Silas shook his head. "Trust the person," he said. "Read the paper." Later, he gave me the version of that lesson I never forgot. "You may not have much money, Maren, but do not sign anything you have not read to the last line." Vail Harbor Freight did not become successful quickly. One winter nearly destroyed it. 2 trucks broke down within the same week. A customer refused to pay on time. Silas borrowed against everything he owned and slept in the garage more than once. He survived by finding loads for trucks that would otherwise return empty, taking small, cold storage contracts larger companies ignored, and keeping promises to drivers who had been treated as disposable elsewhere. The company grew one route at a time. So did we. I decided to study law after one of our longtime drivers lost part of a settlement because he had signed an agreement he did not understand. He had not been wrong. He had simply been outmatched by the language on the page. I wanted to understand that language. When I entered law school in 2019, My financial aid did not cover everything. Silas sold the first tractor unit he had ever owned. I was furious when I found out. That truck started the company, I told him. He looked toward the empty space where it had been parked. I did not sell our history, he said. I made sure my daughter would never be helpless in front of a piece of paper again. Evan supported the decision, but I saw the pause before he said so. He had turned down the chance to study out of state and stayed beside Silas as the company expanded. He never blamed me, but I began to understand that love and hurt could occupy the same room. I passed the Maryland bar in 2022 and joined Hartwell and Pike in Washington, D.C. I worked on trust disputes, internal investigations, and corporate governance cases. By 2025, I had 3 years of serious experience. I was capable. I was not famous. And I had never handled anything as large as the crisis waiting for my family. At the dinner after I passed the bar, Silas raised his glass and said I had learned how to protect myself. Evan looked through the window toward the old garage. One day, he said, you may have to protect something Dad thinks no one can take. I thought he meant contracts, voting agreements, or the increasingly complicated paperwork of a growing company. 3 years later, I understood what he had sensed before I did. The first thing they tried to take from my father was not his company. It was his right to tell the truth about his own life. Chapter 2. The Empire That Outgrew Our Family. Looked You, Chapter. By 2016, the company my father had started in a leaking garage no longer fit inside the life we had built around it. Vail Harbor Freight had become Vail Atlantic Logistics, a network of refrigerated warehouses, intermodal yards, and freight routes stretching from Maryland through Pennsylvania and into Ohio. By 2025, nearly 4,800 people depended on the company for a paycheck. Independent analysts valued it at close to $860 million. Silas still wore the same canvas jacket to work. He still ate lunch with drivers when he had time. He still walked through the repair bays without announcing himself and asked mechanics whether they had what they needed. But he no longer knew every employee by name. The business had grown beyond handshakes, memory, and the belief that good people would naturally do the right thing. My father did not understand that until it was almost too late. In 2015, Vail won a logistics contract connected to the Department of Defense. It was not glamorous work. We moved equipment, refrigerated supplies, and replacement parts through a network of ports and rail connections. The contract gave the company enough stable revenue for Silas to buy back shares from an early investor who wanted out. When Vail took on institutional capital the following year, Silas hired Thomas Keene, a respected Maryland attorney, to help protect the founding shares. Thomas created the Vail Founders Stewardship Trust. Silas kept 32% of the voting power in his own name. The trust held another 19%. Together, the founding bloc controlled 51% of the company. At the time, I knew almost none of that. Silas told me only that my name appeared in certain succession documents. He made it sound administrative, something that might matter decades later if he retired or became too ill to make decisions. He did not tell me the trust held actual voting shares. He did not tell me I had been named its successor protector once I turned 28 and became a licensed attorney. He did not explain any of it to Evan either. Silas believed secrecy would prevent competition between us. He thought it would keep me out of boardroom politics and spare Evan from feeling that his father had placed legal authority in the hands of his adopted daughter. It was a decision made from love. It was still a mistake. June Holloway understood that before any of us did. June had worked with Silas since the company was small enough for payroll records to fit inside 2 metal filing cabinets. By 2017, she was responsible for corporate records and governance notices. Every year, she sent an annual certification of trust authority to the corporate secretary. She saved the delivery confirmations, indexed the correspondence, and maintained paper backups even after the company moved most of its records online. June had silver hair, careful handwriting, and no patience for executives who treated documentation like clerical decoration. She warned Silas more than once. "The company is too large for people to rely on what they remember agreeing to," she told him. Silas always nodded. Then he postponed the reforms. He believed culture could protect what paperwork could not. That belief made Barton Kingsley look useful. Barton joined the board as Vail Atlantic prepared for another round of expansion. He had spent decades advising transportation and infrastructure companies. He spoke calmly, dressed perfectly, and never raised his voice when a well-placed sentence could make someone feel unqualified. He did not arrive sounding like a villain. He talked about professional governance, institutional discipline, and reducing founder concentration risk. He said Vale needed a clearer succession plan. He argued that a company with thousands of employees could not depend on the judgment of one man, even if that man had built it. Some of what he said was true. That was what made him dangerous. Silas believed they disagreed only about style. My father trusted people who stated their position directly. Barton understood that and made sure every concealed intention wore the language of responsible management. Priscilla Van Dorn entered the picture through a proposal to finance an expansion of our rail network. Van Dorn Capital Partners presented itself as a long-term investor with the resources to transform Vale Atlantic into a national logistics platform. Their presentation showed new terminals, improved tracking systems, and stronger lender relationships. Evan read the pages most executives skipped. Buried in the operational scenarios were plans to sell 2 cold storage facilities, close less profitable routes, move hundreds of employees to outside contractors, and reduce medical and pension obligations. Evan brought the documents to Barton. Barton called them contingency models. "Every serious lender expects downside planning," he said. Evan did not believe him. "I was in Washington when I first noticed the trust certifications had disappeared from recent board packets. I sent Silas a short legal memorandum. I told him Barton controlled too much of the records process. I told him the shareholder agreement needed to be updated. I warned him that the founding block only protected him if the 19% held by the trust could not be challenged." Silas called me that evening. "Barton is practical," he said. "He is not a thief." I did not call Barton a thief. I told him control of information was often more valuable than control of money. Silas promised to review it after the next quarterly meeting. He never did. Around the same time, June discovered that her system permissions had been reduced. The annual certifications she had filed were moved into a folder marked Archived Legacy Documents. Then, Barton asked her to sign an affidavit stating that the board had not formally acknowledged the trust in recent years. June read every line. She refused. 2 weeks later, she was placed on administrative leave as part of what Barton called the modernization of records management. Silas was told the change was temporary. June knew better. The first evidence of what Van Dorn planned to do came from Rosa Martinez. Rosa managed the Dundalk cold storage facility. She had worked for Vail for almost 18 years and could identify a failing refrigeration compressor by the sound it made through a concrete wall. Her daughter had died young, and Rosa was raising her granddaughter. The health insurance Vail provided was not a benefit she considered optional. She found a draft labeled Workforce Optimization in a planning directory that had not yet been locked. It projected that approximately 1,400 positions could be eliminated or transferred to contractors without the same benefits. Rosa printed the document and gave it to Evan. He drove to Silas's office before sunrise. "They do not want to invest in Vail," Evan said. "They want to borrow money against our assets, buy the company with that debt, and make our employees pay it back." Silas looked through the pages. "There is no final merger agreement," he said. "There does not have to be one for this to be real. We cannot run a company on suspicion." Evan placed both hands on the desk. "Dad, You are still running a company worth almost $1 billion, like everyone is shaking hands in the garage. Silas did not answer. Evan called me next. I was preparing for a hearing in a trust dispute and could not leave Washington that afternoon. I told him the document mattered, but we needed to authenticate it before anyone went public. That was not what he wanted to hear. "You can leave and come back when the paperwork becomes important," he said. "I have to look at 4,800 people every day." The words hurt, because there was truth inside them. Evan had stayed. He had spent years dealing with broken equipment, labor disputes, weather delays, and customers who expected freight to move no matter what failed in the middle. I told him if he released an unverified draft, Barton would claim our family was manipulating the board to protect Silas. Evan went quiet. "You always know what not to do," he said. "That must be easier from Washington." He ended the call before I could answer. A few days later, Barton asked Evan to meet privately. I did not learn the details until much later. Barton told him Silas had no real succession plan because he did not trust his own son. He said I had been given a role in the trust, while Evan had been left to manage trucks and warehouses. Then he offered Evan a future. If Evan supported a leadership transition, Barton said he could remain chief operating officer after a merger with Van Dorn. Evan did not accept. He did not refuse either. At the time, that silence would become one of the most frightening things between us. The document that changed everything reached me on a Thursday morning. June sent me a scanned copy she had received from an anonymous source. It appeared to be a board consent from 2016. The pages described value connected to the defense logistics contract and a transfer involving a family trust. Silas's signature appeared at the end. It was not a blurry copy or an obvious imitation. I had seen his signature on birthday cards, loan agreements, company documents, and the papers that made me his daughter. It looked real. I called him immediately. He answered on the third ring. I asked if he was alone. He said yes. I looked again at the signature and felt the old brass key beneath my shirt, where I still wore it on difficult days. "Did you sign this document?" I asked. Silas did not answer at once. For the first time in my life, his silence did not feel patient. It felt guarded. Then he spoke. "Yes," he said. "I signed it." The lie built from a real signature. I left Washington before sunset and drove north through rain that followed me almost the entire way to Baltimore. Silas was waiting in the kitchen when I arrived. His canvas jacket hung over the back of a chair. Evan stood near the window with his arms folded, staring toward the dark yard, as if the answers might be outside. The scanned document lay on the table between them. I placed my bag down and looked at Silas. "Tell me exactly what you signed." He pulled out a chair, but did not sit. "In 2016, one of our early investors wanted out. The defense logistics contract had given us enough cash flow to buy back his shares. Thomas Keene structured the transaction." "And the trust?" "Yes." Silas explained that the shares had been purchased legally, then transferred into the Vail Founders Stewardship Trust. No company money had gone into an account for me. No funds had been hidden under my name. The trust held voting stock. I turned the document toward him. "Then why am I in this?" Silas looked at Evan before answering. "Because Thomas named you the successor trust protector." The room became very quiet. I felt the brass key beneath my shirt. "You named me what?" "The trust protector," he said. "Once you turned 28 and became a licensed attorney." I stared at him. A trust protector was not a beneficiary. I could not withdraw money, sell shares to myself, or inherit control of the company. My role was supposed to be independent. If there were a hostile takeover, a conflict involving the trustee, or an attempt to suppress governance records, I could ask a court to protect the trust's voting rights. I understood the legal design immediately. What I could not understand was why no one had told me. You handed me a key when I was 14 because you wanted me to know I belonged in your home. Silas lowered his eyes. But you hid the key to something that could tear this family apart because you decided I did not need to know. I was trying to protect you. From what? From becoming part of a fight you never asked for. I looked at Evan. He had gone still. And him? Silas rubbed a hand over his face. Evan was always meant to lead operations. The trust protector had to remain independent from anyone managing the company. Evan gave a short, humorless laugh. So she got independence, and I got a job description. That is not what I meant. No, Dad, it is exactly what you meant. You made a future for both of us, and told neither of us what it was. Silas stepped toward him. I did not want you competing. Evan looked at him then. You do not prevent competition by hiding the finish line. Silas had made the decision out of love. I believed that. It did not make the damage smaller. You cannot protect adults by keeping them outside the truth, I said. At some point, that becomes control. By the next morning, Barton Kingsley had turned the truth Silas concealed into the lie that nearly destroyed him. Rebecca Sloan called me before 9. She was a business reporter in Baltimore with a careful reputation and a voice that never revealed which answer she expected. I have documents showing your father transferred value connected to a federal defense contract into a family trust naming you. Do you have the entire agreement? I have the board consent and supporting pages. Count them. She paused. What? Count the pages. Then check whether the page numbers, fonts, and dates match. My source says the packet is complete. My father's signature may be real. That does not mean the document in front of you is. Are you denying that the trust exists? I am telling you, I will not authenticate a document I have not examined. Rebecca gave me until noon. The story went live at 12:14. Founder used military contract profits to enrich adopted daughter. The consequences came faster than any formal investigation could have. A bank placed Vele's revolving credit line under review. A federal customer postponed negotiations on a new contract. 2 major clients demanded written assurances that the company's leadership remained stable. Employees began calling supervisors to ask whether payroll was safe. Van Dorn Capital Partners issued a statement saying it remained prepared to provide stability if Vale's board requested assistance. They created the fire, then stood outside holding a bucket. Barton called an emergency board meeting that afternoon. I attended remotely with Daniel Reeves, the attorney Silas had retained. Evan sat beside our father in the boardroom. June was not allowed into the meeting because she was still on administrative leave. Barton spoke in the same measured tone he used when describing layoffs as operational efficiencies. Silas has acknowledged the trust, the transfer, and the involvement of a close family member. Until these transactions are independently reviewed, he should temporarily step away from executive authority. Silas leaned toward the microphone. I created a legal voting trust. I did not enrich my daughter. You signed the transfer documents. I signed a share transaction. And Maren Vale appears in the succession structure. Yes. Barton let the answer sit in the room without context. That single word reached the press before the meeting ended. By evening, it was being reported as a confession. Owen Price, one of the independent directors, did not support removing Silas as CEO, but without an authenticated copy of the trust, he voted to restrict Silas from acting alone on any merger, trust matter, or major asset transaction. The motion passed. My father kept his title. He lost the power to stop the machinery moving around him. Daniel filed preparations for emergency relief in the United States District Court for the District of Maryland. The complaint involved allegations of wire fraud, manipulated records tied to a federal contract, and an urgent transaction crossing state lines. The court could hear the federal claims and the related governance dispute. We divided the work. Daniel represented Silas. Rachel Boone, a partner at Hartwell and Pike, agreed to represent the trust independently. I would assist as the newly disclosed successor trust protector, but I would not serve as the trust's primary counsel. If I testified, Rachel or Daniel would question me. Dr. Naomi Feld began tracing the financial relationships around Barton and Van Dorn. Caleb Monroe started examining the scanned document and its metadata. June gathered every receipt and filing reference she still possessed. I went looking for the trust. Thomas Keene had retired years earlier. His old Annapolis office had closed, and the firm that purchased his practice had transferred archived files to a records facility in Harrisburg, Pennsylvania. I drove there the next morning. The clerk searched the database twice. The Vail box was transferred out 7 weeks ago. Transferred where? The destination field is restricted. Who authorized it? She printed the request. June Holloway's signature appeared at the bottom. I called her from the parking lot. June, did you authorize the transfer of Thomas Keene's Vail files? No. Your signature is on the request. My signature has not looked like that in 20 years. The box was gone. For the first time since the crisis began, I had reached a locked door with no legal argument strong enough to open it. The call from Adelaide Mercer came while I was driving back toward Maryland. She was the managing partner of Mercer Hale, one of the New York firm's attorneys at my level talked about in lowered voices. "We have been following your work," she said. "You have a future beyond this family conflict." She offered me a partner track position, a salary large enough to change my life, and immediate access to corporate cases I might otherwise wait years to handle. Then she mentioned the condition. Mercer Hale represented parties whose interests could overlap with Vail Atlantic. I would need to sign a conflict waiver and withdraw from every matter involving my father's company. I knew Van Dorn had used Mercer Hale before. "I need time," I said. "Of course, but these opportunities do not remain open indefinitely." Silas learned about the offer from Daniel. He called me that night. "You should take it." "You do not know what they are asking." "I know you worked for this." "If I withdraw, will you think I abandoned you?" His answer came without hesitation. "I did not adopt you so you would save me one day." I closed my eyes. "I would rather lose the company than turn love into a debt," he said. The next morning, I saw Evan enter Barton's office. An hour later, our legal team lost access to part of Vail's internal data room. That afternoon, a draft memorandum I had sent only to Evan appeared as an exhibit in Barton's court filing. I found my brother in the operations center. "Did you give him my memo?" "No." "Then how did he get it?" "I cannot explain that yet." "Why were you in his office?" He looked exhausted but not surprised. "You told me not to react before I had evidence." "This is not an answer." "It is the only one I can give you." For the first time since I had entered the Vail house, I did not know whether Evan was standing beside me or across from me. I met Adelaide again in Washington 2 days later. Daniel had confirmed that District of Columbia law permitted me to record a conversation to which I was a party. Adelaide placed the employment agreement in front of me. "You do not have to say anything against your father," she said. "No one is asking for betrayal." "Then what are you asking for?" She folded her hands. "We need to know. You will not appear in a place where your involvement could complicate the transaction." My phone recorded every word from inside my bag. It was useful. It was not enough. I could not yet prove Adelaide was acting under Priscilla Van Dorn's direction. I could not prove who had moved the trust records. I could not fully explain how Silas's signature had been attached to the document being used against him. And I no longer knew whether I could trust my own brother. Daniel called as I left the building. "Barton filed for an emergency preliminary injunction." "When is the hearing?" 4 days. I stopped on the sidewalk. "And the merger vote?" 5 o'clock the same day. Traffic moved past me under a gray Washington sky. Someone had tried to purchase my absence. My father's voting rights were about to be placed in the hands of a judge. The certified trust document was still missing, and we had 4 days to prove that a lie built from a real signature was still a lie. Chapter 4. The people they thought didn't matter. June arrived at Daniel's office before sunrise, carrying 2 canvas document bags and a black ledger that looked older than half the executives on Vail Atlantic's board. She set everything on the conference table and removed a 4-page affidavit. "Barton asked me to sign this 3 weeks ago." Rachel Boone pulled the document closer. It claimed the annual certifications for the Vail Founders Stewardship Trust had not been filed consistently, and that the board had no reason to believe the trust remained active. June's signature line was blank. "You refused," Rachel said. I read it. June opened the first canvas bag. Inside were delivery confirmations, printed emails, transfer receipts, handwritten index sheets, and copies of notices dating back to 2017. I filed the certification every year. When they reduced my access, I started printing everything. Daniel examined one of the receipts. "Why were you placed on administrative leave?" "Because Barton needed that affidavit before the merger." Silas stood near the window, his hands in his pockets. "You warned me." June looked at him without anger. "Yes. I thought he was reorganizing the record system." June closed the ledger. "Your father thinks other people take promises as seriously as he does." She turned toward me. "That is a good quality in a father. It is a vulnerability in a chief executive." Silas did not defend himself. Caleb Monroe called us into the next room an hour later. The disputed document filled 2 large monitors. "The signature is authentic," he said. Silas's name appeared at the bottom of the final page. Caleb opened a second file beside it. "This is the signed page from the original 2016 board consent. Same compression pattern, same fold mark, same scanning defect near the lower margin." "So they copied a real signature page," I said. "They attached it to a different packet." He enlarged the page numbers. The original notary log described an 8-page document. The packet Barton submitted contained 11 pages. Several pages used a font version that did not exist when the document was supposedly executed. The pages describing a transfer for Maren's benefit were created or modified in 2025, Caleb said. "I can establish that the packet was assembled from separate sources." Daniel folded his arms. "Can you establish who assembled it?" "Not yet." The document had been manipulated. That did not automatically prove Barton had manipulated it. Every fact still needed a bridge. Naomi Feld arrived that afternoon with a financial chart spread across 3 sheets of paper. She traced a line from Van Dorn Capital Partners to a Delaware consulting company, then to a shell entity controlled by one of Barton's longtime associates. $2.4 million, she said. It is listed as a strategic advisory fee. When was it paid? I asked. 6 days before Rebecca Sloan received the first allegations. Naomi placed another document beside the chart. Barton also receives an option to purchase equity in the surviving company if the merger closes. Daniel studied the papers. That gives us a conflict of interest. A strong one, Naomi said. It does not prove bribery by itself. None of our evidence was a miracle. It was a collection of facts that would have to support one another under pressure. At the Dundalk facility, Rosa Martinez found the part of Van Dorn's plan that Barton had kept away from the board. She met Evan in a maintenance office above the refrigerated loading bays. Below them, forklifts moved through white vapor while trucks backed into the docks. Rosa handed him the full workforce plan. They call this optimization, she said. My granddaughter calls our insurance the reason she can breathe. The plan proposed selling 2 cold storage facilities, converting hundreds of workers into contractors, reducing pension contributions, and eliminating or restructuring approximately 1,400 jobs. The acquisition would be financed largely through debt secured by Vale Atlantic's own assets. Van Dorn intended to make the company pay for its purchase. Evan sent the plan to Owen Price. Owen called him almost immediately. This is not what the board received. The board received a summary. The summary showed temporary staffing adjustments. The full document shows 1,400 families. Owen went silent. Who else has this? Not enough people. The next break came from the memorandum that had appeared in Barton's court filing. I had sent the draft only to Evan. At first, it looked identical to the version stored on my laptop. Then I noticed a faint mark beside the footer on page 6. It was a tracking watermark. I found Evan in the operations center with several access logs open across his monitors. You marked the memo. He looked up. Yes? You wanted Barton to receive it. I wanted to see which account uploaded it. My anger did not disappear. It changed direction. You went into his office to get access to the data room. I let him believe I was considering his offer. You could have told me. If I told you, you would have told Daniel. If counsel directed it, Barton's lawyers could attack how the evidence was collected. You let me think you betrayed us. His face tightened. I let Barton think I might. That is not the same thing. No. He looked away. But it was the only way he would open the door. Evan connected a small USB drive and pulled up the access history. An account assigned to Barton's executive office had moved the trust certifications out of the board packets. The same office had downloaded the 2016 signature page shortly before the lawsuit was prepared. An account associated with a Van Dorn consultant had accessed the draft merger before the full board was told it existed. The complete workforce plan had been replaced with a shorter version that removed the job loss figures. Evan copied everything to the drive. Before handing it to me, he kept his fingers around it. I was afraid Dad trusted you more. The admission was so direct that I stopped reaching for the drive. He looked through the glass wall toward the dispatch floor. I was not angry because you were named in the trust. I was angry because I spent my whole adult life here, and I still did not know whether I had a place in the future. I saw the 15-year-old boy who had left a folded blanket outside my bedroom because he had not known how to welcome me. I have spent my whole career afraid people would think I earned everything because Dad felt sorry for me. Evan released the drive. You kept the company alive every day, I said. I only learned how to protect what you kept alive. He nodded once, then protected. Rebecca Sloan called while I was driving back to Daniel's office. My source gave me an incomplete packet, she said. Are you retracting the story? Not yet. Your father signed a related document, and the trust exists. That is fair. But I am publishing an update. The integrity of the packet is disputed, and I am delaying the follow-up until the records are examined. Rebecca was not becoming our ally. She was correcting what she could verify. That mattered more. June found the missing trust path that evening. She sat on the floor surrounded by old index sheets until she located a notation from Thomas Keene's office. In 2016, Thomas had sent a certified archival counterpart of the trust to the insurance company that underwrote the stock transaction. It was not the original physical document. It was an authenticated copy created when the trust was executed. Daniel and Rachel requested an expedited subpoena. The insurer agreed to provide a certified electronic copy with an affidavit, while the formal paper version traveled by overnight delivery. The court approved the accelerated process because the hearing was only hours away. The document arrived shortly after midnight. Rachel read the controlling provisions aloud. The trust held 19% of Vail Atlantic's voting shares. I had no power to withdraw money or transfer shares to myself. I was the successor trust protector. If there were a hostile change of control, a trustee conflict, or a suppression of governance records, I could seek injunctive relief and request the appointment of a special voting trustee. I could not seize the votes. I could ask a court to protect them. Then Rachel reached the independence clause. The trust protector must act independently of the founder's family, and current management. She looked at me. If Silas violated the trust, would you ask the court to stop him? Yes. Silas stood in the doorway. Rachel turned toward him. You understand what she just said? He nodded. If the trust cannot protect the company from me, then it was never protection. That was when I understood the clause was not asking me to prove loyalty. It was asking me to prove judgment. Adelaide sent the final employment agreement the following morning. The conflict waiver and signing bonus had to take effect before the hearing. Naomi traced the bonus funding through a litigation reserve connected to Van Dorn. The connection was suspicious. It was still not proof that Priscilla had personally ordered Adelaide to remove me. I signed nothing. I also did not announce that I had refused. Daniel and Rachel prepared the exhibits under seal. June, Caleb, and Naomi completed sworn declarations. Rachel could file the trust documents even if I never reached the courtroom. My appearance mattered. It was not the only thing holding the case together. On the morning of the hearing, Barton invoked an emergency board action provision in Vail's bylaws and moved the merger vote forward. The stated reason was that Van Dorn's lender had imposed a deadline before noon because Vail's credit position was deteriorating. The procedure gave Barton cover. The timing exposed his fear. Silas entered the courtroom without seeing me at the legal table. I was downstairs in the clerk's office while Rachel completed authentication of the sealed exhibits. Through the open doors, Barton looked toward my empty chair and leaned toward Elliot. Even she knows Silas is not worth saving. My phone vibrated as the clerk stamped the final filing. The board vote had been moved again. It would begin in less than 90 minutes. I lifted the document case. Inside were 5 groups of evidence, none of them decisive alone. The certified trust copy, June's records, Caleb's forensic findings, Naomi's financial trail, the recorded effort to purchase my absence. Every document still had to be authenticated. Every witness still had to survive cross-examination. Every connection still had to persuade a judge before the board completed its vote. Daniel was already inside, trying to stop the court from suspending my father's rights before we could present the full record. I walked down the marble corridor. Then, I opened the courtroom door. Chapter 5. The woman they called his weakness. Every head in the room turned toward me. Silas looked relieved for less than a second. Then his expression changed, as if he had remembered that my presence did not guarantee anything. Rachel Boone rose and informed Judge Margaret Ellison that the Vail Founders Stewardship Trust was ready to present authenticated exhibits and that I was present as the successor trust protector and a limited fact witness. Elliot Wainford objected immediately. He argued that I was Silas's daughter, an attorney, and a person named in the trust. According to him, I could not possibly be independent. Judge Ellison studied me over the top of her glasses. She allowed Rachel to continue, but limited my testimony to the trust, my appointment, the employment offer from Mercer Hale, and whether I could perform my duties independently of Silas. The first exhibit was the certified archival counterpart of the Vail Founders Stewardship Trust. Rachel authenticated it through the insurer's affidavit and the records from the 2016 stock transaction. The document confirmed that the trust held 19% of Vail Atlantic's voting shares. It was not a bank account created for me. I had no authority to withdraw money, sell the shares to myself, or use the trust for personal benefit. Its purpose was to protect the company against a hostile change of control, conflicts involving the trustee, and the suppression of governance records. For the first time since the scandal began, the central accusation against Silas began to weaken. Elliot did not let it collapse. He argued that the trust might have been valid in 2016, but its authority had not been recognized by the board in recent years. He pointed out that the annual certifications were missing from the board packets. Judge Ellison looked toward Rachel. The trust was legal, but we still had to prove it remained active and had been properly disclosed. June took the stand. She presented delivery receipts, annual certifications, index entries, and emails documenting every filing from 2017 through 2025. Elliot asked whether she expected the court to rely on the memory of a retired records employee. June did not react to the insult. She placed both hands on the witness table. "I am not asking the court to trust my memory," she said. "My job was to make sure no one had to." Caleb then presented the access logs. The certifications had not disappeared because June failed to file them. They had been moved out of the board packets after Barton's executive office took control of the records system. The second argument against the trust began to fall apart. Then Caleb addressed Silas's signature. He showed the original 2016 board consent, the notary log, the 8-page record, and the 11-page packet submitted by Barton's side. Silas had signed the purchase of voting shares and their lawful transfer into the trust. The signature page was real. The pages attached to it were not the pages he had signed. Several had been created or modified in 2025. Judge Ellison turned to Elliot. "Where did your clients obtain this packet?" she asked. Elliot glanced at Barton before answering. He said the documents had been supplied by his clients and that he had not been informed of any discrepancy. Barton leaned forward. "A reconstructed packet does not change the economic reality," he said. "Vail Atlantic is in distress, and Van Dorn is the only buyer prepared to stabilize it." For a moment, he regained control of the room. Even if the accusation against Silas was flawed, Barton argued that the merger could still benefit the shareholders. That was when Naomi Feld presented the financial trail. The $2.4 million strategic advisory fee had traveled from a company connected to Van Dorn into a shell entity controlled by one of Barton's associates. Barton would also receive the right to purchase equity in the surviving company after the merger. The leaked allegations, the reduction in Vail's internal valuation, the lender pressure, and Van Dorn's offer of $545 million all followed in sequence. No single document said they had manufactured the crisis. Together, the timeline showed who benefited from it. Evan testified next. He admitted Barton had offered to keep him as chief operating officer if he supported the leadership transition. Elliot asked whether Evan had ever resented my place in the family or the trust. Evan said yes. He admitted he had sometimes felt excluded from the company's future. Then he looked toward the judge. "My feelings do not change the access logs," he said. "The court does not have to believe I am a good brother. It only has to read the data." The full workforce plan was authenticated through Evan, Rosa Martinez, and Owen Price. It proposed selling 2 cold storage facilities, reducing benefits, moving workers to contractor status, and eliminating or restructuring approximately 1,400 jobs. Vail Atlantic's assets would secure the debt used to buy the company. Owen confirmed the board had never received the complete plan. He said he would not have voted to restrict Silas if he had known what Barton had withheld. Elliot turned to me last. He asked about the night Silas found me near the bus terminal. He asked about the adoption, the house in Dundalk, the truck Silas sold, my tuition, my legal career, and the Vail name attached to every professional achievement I had earned. He wanted the court to see gratitude as a conflict. I did not deny any of it. Silas gave me a home, an education, a family, and the first place where I did not have to ask permission to stay. Then I told the court what I had learned about debt. A debt is something a person repays so they can be free of it. A principal is something a person keeps because they have chosen who they intend to become. The documents would have meant the same thing if Silas had never been my father. Elliot asked whether I would ever act against him. I said I would. If Silas concealed records, sold trust shares for personal gain, or used the trust to preserve his own power at the company's expense, I would ask the court to stop him. Silas gave one small nod. Judge Ellison noticed. Rachel then introduced the Mercer-Hale offer. The court reviewed the employment agreement, the conflict waiver, the signing bonus, the meeting record, and the recording made in Washington. Adelaide had not asked me to lie. She had said no one needed me to betray Silas. They only needed me absent from the place where I might complicate the transaction. Elliot argued that Adelaide had not been proven to act for Priscilla Van Dorn. Rachel produced an email showing Adelaide had reported the result of our meeting to Van Dorn's outside counsel. It was not a criminal conviction. It was enough to make the transaction look anything but independent. Daniel checked his phone and stood. The emergency board vote was scheduled to begin in minutes. Judge Ellison called a brief recess. In the hallway, Silas came toward me slowly. "I thought you had gone," he said. "If you had known the plan, you would have tried to protect me. You might have exposed it." He looked down. "I should have told you about the trust." I did not need an apology for believing I was capable. I needed him to understand that protecting a family did not mean keeping that family outside the truth. This time, he said he understood. When we returned, Judge Ellison issued her order. She refused to suspend Silas's direct voting rights. She found that the trust had shown a substantial likelihood of proving its authority over the 19% block. She stopped the merger and the emergency board vote. She appointed an independent special voting trustee under court supervision and allowed me to continue as trust protector without granting me personal control of the shares. Barton was barred from decisions involving the trust, the merger, Van Dorn, and preservation of the disputed records. All relevant data had to be preserved. The evidence concerning altered documents and possible witness interference would be referred to the proper authorities. No one was arrested that morning. No one was declared guilty. But the transaction was dead. Barton lost because he had dismissed the people he believed did not matter. He underestimated June because she kept records. He underestimated Rosa because she managed a warehouse. He underestimated Evan because he thought hurt could be purchased with a title. He underestimated me because he mistook love for weakness. Within weeks, Barton was suspended as chairman. Van Dorn withdrew from the merger and faced civil claims from investors. Elliot ended his representation after learning how much information had been withheld from him. Vail Atlantic survived, but it did not return to the way it had been. Silas admitted that trust between people could not replace corporate governance. The company created an independent audit committee, a compliance division, a stronger record system, a transparent succession plan, and an employee advisory council. Evan remained in charge of operations, but no one named him the automatic heir. June supervised the restoration of the record system before retiring on her own terms. Rosa joined the employee council. I became an independent legal advisor to the trust, not the owner of the company and not the keeper of my father's power. Several weeks later, Silas and I stood together at Sparrow's Point. Trucks moved through the yard. The cold storage buildings were still open. The intermodal line continued carrying freight west. I took the old brass key from beneath my shirt and placed it in his hand. He looked down at it. "Why are you giving this back?" he asked. It was not the key to his empire. It was not payment for what he had done for me. It was a reminder that before there were shares, court orders, and boardrooms, he had given a frightened child the right to walk through a door without fearing she would be sent away. "I did not adopt you so you would save me one day," he said. "I know." I told him he had only taught me that when someone who belonged to your family was standing outside in the rain, you did not close the door. Silas held the key in his palm. I stood beside him, no longer the girl waiting for an adult to come back, and never the heir to an empire. I was simply the woman who had chosen to stay. Together, we watched the trucks leave the yard beneath a clear sky washed clean by rain. Do you believe family is defined by blood, or by the people who choose to return when you are standing alone? Share your thoughts in the comments, and if you believe quiet loyalty can be stronger than revenge, stay with us for the next story.